Hi there, I'm Prudence, your guide to the wonderful world of fiduciary responsibility. This video series, brought to you by Health Decisions, Inc., is designed specifically for fiduciaries and their ABC teams. That's advisors, brokers, and consultants. This is a shared educational tool that we hope will assist you and your team when dealing with your self-funded health plan. So, however you came to be a fiduciary, you are now subject to federal law that requires you behave like a prudent person. Like me, Prudence. Today's topic is why you would want your plan to be its own legal entity. The magical world of self-funded health plans is defined by a federal law called ERISA, the Employee Retirement Income Security Act. This world roughly divides into two hemispheres. One is populated with plans sponsored by unions. The other contains plans sponsored by employers. Among union plans, almost all are separate legal entities called trusts. In the employer world, many, probably most, health plans exist simply as extensions of the sponsoring company, with no separate legal status of their own. Now, I'm no attorney. I'm actually an avatar, and the people at Health Decisions who created me don't provide legal advice either. But the legal status of the health plan you oversee has practical implications that fiduciaries should understand. Consider a simple example of a benefit denial. Let's say you're hospitalized for something that is not covered, like an experimental procedure, which most plans don't pay for. Well, you don't think this is fair, and so you decide to do something about it. Let's take a look at what would happen if your plan was a separate legal entity versus if it was not. Under the ERISA plan that's a separate legal entity, you can appeal, but if denied, can only appeal the fiduciary's judgment. For a plan that is not a separate legal entity, you can sue the employer for breach of contract or employment agreement and take that employer to court. The ERISA plan tells me what appeals rights exist and determines what information is needed for an appeal. For a plan that is not a separate legal entity, there are legal proceedings to determine what information is demanded from the employer with subpoenas, and testimony is now fair game. Under a plan that is a separate legal entity, only federal law applies. State laws are overruled by the ERISA preemption. For plans that aren't a separate legal entity, state laws, regulations, and mandates can be brought into the appeal. Under the ERISA plan, what fiduciaries must do to meet their responsibilities and avoid liability is clearly defined. Act solely in the interests of the plan. Without a separate legal entity, legal liability is determined by litigation and court decisions. Phew, so after all of that, Prudence says, set up your health plan as a separate legal entity. If the plan you oversee is set up as a separate legal entity, you have a level of protection that does not exist in plans that lack separate legal status. For more specific legal advice, you should consult with an ERISA attorney. The ERISA attorney who helped us with this video is John Egertson of Egertson & Associates. Questions for me? Topics you'd like to see covered? Call 1-855-PRU-SAYS. That's 1-855-778-7297. Ask for me, Prudence. We'll see this video series as an ongoing effort that will be guided by viewers like you. And, as always, feel free to reach out to us on YouTube, Twitter, LinkedIn, and healthdecisions.com. where we have tons of resources, as well as a contact page. We'd love it if you encouraged your colleagues to watch and share these videos as well. Thanks for tuning in.